826. Court has been asked to assign a guardian and a conservator in this particular file. May I have the names of our participants for the record, please, beginning in the courtroom.
Michael McFarland, attorney, guardian at Litem.
Good morning, Jessica Kelly, on behalf of the petitioners, Mr. Ned McCormick and Dr. Jennifer McCormick, who are joining us in person and on Zoom.
All right, Ms. McCormick, let's go to you next. You can introduce yourself and who you have there with you.
I'm Jenny McCormick, and I have Melvin Dickerson, also known as Mel.
Thank you. Okay, and then I have Kirk, Julie, and Andre Dickerson. Welcome, family members. Is that right? Very good.
Krista.
And yes, and is Krista Williams also family member?
Yes.
All right, very good. Okay. Ms. Kelly.
Good morning. Petitioners are longtime family friends of Melvin Dickerson's. Mr. Dickerson was never married or had kids, but he has
married, but
Oh,
divorced.
I'm sorry. Thank you. He is not currently married.
Let me just say one at a time, please, so we know.
My
who's
apologies.
talking for the record. Okay.
Mr. Dickerson is not currently married and does not have children, but he has been close to the McCormick family for many years. In 2012, Mr. Dickerson executed valid powers of attorney for his finances and healthcare decisions, naming Ned McCormick, an accountant, as his financial agent, and naming Jennifer McCormick, a PhD at a medical school, as his patient advocate. Mr. Dickerson's nieces and nephews are his next of kin, and they are aware of these petitions. We've also had the opportunity to have some phone calls and answer some questions, and we believe there are no objections. In recent years, Mr. Dickerson has developed Alzheimer's dementia, and his doctors have indicated that he no longer possesses the capacity to make decisions about his care or finances. When the McCormicks have attempted to help him with his finances using the POAs, they have had some trouble, specifically a Carta Credit Union. They are seeking appointment as co-guardians and appointment as conservator by this court so that Mr. Dickerson's wishes will be honored and their authority to assist their friend will be recognized by all institutions as his needs progress. Along with her petition for appointment of co-guardians and petition for conservator, the McCormicks have provided a letter from Dr. Raffi describing Mr. Dickerson's diagnosis and impairments and recommending that he have assistance, and the report of physician that agrees with Dr. Raffi's assessment. In addition to the documents prepared by these professionals, Mr. McFarland has been serving as the GAL and has prepared a report as the GAL. We are prepared to provide testimony from the petitioners if it is helpful for this court in making the necessary findings to grant both petitions, and I'm sure Mr. McFarland is happy to share as well. Thank you.
Okay, any comments, Mr. McFarland?
Yes, Your Honor. I've been to many probate seminars, and I think the bank is wrong in that you don't have to contemporaneously sign the acceptance of the power of attorney when the original durable power of attorney was signed. But I did receive a letter from a copy of what the bank sent to the power of attorney, and they suggested, well, they would not honor it. And their suggestion was you can attempt to get a certificate validation from Mr. Dickerson's attorney or apply to court for a conservatorship. And speaking to the current patient advocate, she's been able to take care of all the medical needs, so that has not been an issue. Talking to the current DPOA, he's been able to handle everything except this one account. So they take some testimony from him and see if the court believes that he's attempted to get validation. And he's advised me that he was playing telephone tag with the attorney, attempt to get that, and so he's asking for the guardianship or conservatorship. I don't think a guardianship is necessary, Your Honor, because everything is being addressed through the power of attorney by everybody except the bank. I think a conservatorship would deal with that, and the power of attorney only indicates one individual, which is Ned, to be the holder of that. So I think that's what Melvin's wishes were. I think I don't think they asked for co-conservators, but I think a conservatorship would deal with that I did have a pleasant conversation with Melvin, but his limitations were clearly noted by me in my report, Your Honor.
Witness testimony today, Ms. Kelly?
Yes, thank you. I'd like to call Ned McCormick, please.
Mr. McCormick, come on for a witness stand.
Raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
There's a step there, be careful.
Morning. Would you please say and spell your name for the record?
Ned James McCormick, Ned James, James, McCormick, McCormick.
Thank you. And what is your address?
5467 Douglas Road, Toledo, Ohio, 43613.
What do you do for a living, Mr. McCormick?
I'm an accountant. I work for Dana Corporation, work out of the Toledo plant.
And how do you know Mr. Dickerson?
He's a family friend from about 30 years ago. My sister brought him home for Thanksgiving one year, and we've kind of adopted him to the McCormick clan.
Very good. And you call him Mel, right?
Yes, we call him Mel.
Okay.
The Melvin always throws me off because I'm not used to that.
Sure. What is Mel's permanent address?
611 West Chicago Boulevard, Tecumseh, Michigan, and I do not know the zip code off the top of my head, but
In Tecumseh, that's
Yes.
fine. But he's not there right now because he's currently receiving some care. Where is he receiving care?
he's at Hampton Manor. It's like 123 Commerce Drive, Dundee, Michigan. The long story short is we can't really leave him alone 24/7 anymore. And it's very challenging to find help. So until we able to find help, we have to put him there because we can't. But yeah, he's
Absolutely.
staying treatment.
But that's temporary for the time being.
Yes.
That's fine. Thank you. Does Mel have a diagnosis?
Yeah, Alzheimer's, dementia. I think they're basically, yeah.
Okay. And how have you observed that Alzheimer's disease affecting his ability to care for himself?
'Cause he doesn't remember to like brush his teeth or, even feed himself. He can do it, but you need to be prompted like, hey, you need to eat. You need to eat the right things, not just ice cream for dinner. He needs to be reminded to take his medications every day, things like that, he just doesn't remember the day-to-day activities. He can do them, but he needs to be prompted to do them.
Does he struggle with finances as well as the day-to-day?
Yeah, he, for the most part, really can't comprehend when if you read something. So, if somebody put a check in there, he'd probably just sign and give away things.
I understand. But he does have some assets that need management, right?
Yes, he has some managements. He has a few assets that need to be managed and make sure they're conserved so we can make sure he has a healthy, happy life.
Very good. Has Mel created any type of financial power of attorney in the past, naming someone to help him in situations like this?
Yes, and I believe it was 2012. He had a financial power of attorney and a medical power of attorney.
Okay. And he named you as the financial agent, right?
Correct. I was named the financial power of attorney.
Okay. But describe the trouble you've had using that financial power of attorney to assist him.
So his checking account to pay his bills. He has is part of credit union. I believe it's based out of either Ann Arbor or Auburn Hills. I'm not sure where their headquarters is. When I submitted the power of attorney, I had it signed and notarized, I believe last fall, and I submitted it to them and they refused to accept it because there was I believe there's a 10-year gap between when he signed it and when I signed it. So they just said I didn't have the authority to write checks with his name or move his funds to the checking account from savings account, things like that.
Which are pretty basic functions, right?
Yeah.
Have you had an opportunity to work with the financial planner yet on all of his assets? Have you-
No, I've talked to him. He has some assets that are in stocks, which I currently believe is at his age and time need to be shifted to a more conservative type investments. That way, if there's a crash, he doesn't lose a lot of money.
Do you know for sure whether those other banks are going to honor your financial POA or whether they're going to give you the trouble that the credit union gave you?
His investment advisor that I've talked to has not had any issues. He does have like a TIAA CREF credit union. I haven't, or I guess it's a 401k, or I haven't really talked to them, but that was just kind of, he has some other assets that I haven't really tried to use the financial POA, but there still potentially could be a problem.
Fair, and that's why we're here today, that's right. So is it true that you signed a petition for appointment of conservator on June 20th of this year?
Correct.
And were all of the statements in that petition true when you signed it?
Correct.
Are they true today?
Yes.
Very good. Do you understand the duties of a conservator?
Yes, I've been reading up on it. In a nutshell, my job is to make sure that his finances are, pay all his bills, make sure he doesn't lose all his money to a bad investment or somebody take advantage of him.
That's right, thank
His
you.
mindset is, that's more what we're concerned about.
Thank you. You mentioned that Mel has some trouble with his day-to-day self-care. Has he created any type of healthcare power of attorney in the past?
Yes, that would be for my sister Jennifer, Dr. Jennifer McCormick.
And who is Jennifer to you as your sister?
She's my sister, and Mel's really close friend.
Okay. And do you know whether Jennifer has had any trouble being recognized as his patient advocate?
So far, no, but since we've had the issue, because she's not a blood relative, and we had the issue with the financial, we just wanted to be sure that we don't run into that issue and his wishes are not carried out, I guess is the word.
Sure, sure. Is it true that you signed a petition for appointment of co-guardian with Jennifer on June 20th, 2022? If Jennifer hasn't had any trouble yet, why are you petitioning to be appointed as co-guardians?
Hey, this is the geographic proximity. If there's ever an emergency, I can be to Mel within a half an hour. My sister currently lives in Hershey, Pennsylvania. It would just, if there is an emergency, I would be able to take care of it.
Very good. Were all of the statements in your co-guardian petition true when you signed that one?
Correct.
And are they all true today?
Correct.
Do you understand the duties of a guardian?
Yes, very similar to the financial, but it's more his medical and day-to-day and make sure that he has a roof over his head and he has a happy life.
Do you understand the added complexity of serving as co-guardians?
Yes, me and my sister, we've discussed this extensively over the last few years. We both are completely aligned of what we believe. But with the medical stuff, I would more defer to my sister because that's her area of expertise and that's what Mel wanted. For me to be co-guardian is more of the fact that if there was an emergency, I would be right there to take care of it.
I see. And you are asking the court to appoint you as Mel's co-guardian along with your sister, right?
Correct.
Have you received any feedback from Mel's nieces or nephews?
A little bit. I believe they're okay with everything.
Thank you. That's all I have for you.
Okay, thank you.
Ms. McCormick?
Just a couple of questions. I appreciate you forwarded the letter to me from the credit union, correct?
Yes.
And they said that they would not, they rejected your power of attorney because it was your acceptance was over a decade from when it was signed, correct?
Correct.
They suggested you either get a conservatorship or number one, you can attempt to get a certificate / validation from Mr. Dickerson's attorney. What attempts did you make to get that validation certification?
I made a phone call to her and I talked to her. It was like a Friday afternoon and we ended up paying a lot of phone tag and I would ask her a question. I know attorneys are very busy, so, but it just wasn't getting anywhere. So I decided I would go with the option B.
Who was the attorney?
Edith. I don't know her last name at the moment. I could get that.
Did you send her an email telling her?
No, I did send an email, never got a response, and I've called her on the phone and talked to her once or twice.
And did she say that she could provide authorization or not?
She didn't really answer. I didn't get a clear answer. She's like, oh, we can work on a guardianship or conservatorship.
Fair enough, thank you. And you would agree that on the power of attorney, a DPOA that Melvin made, you were listed as the only individual.
Correct.
Okay. And as far as a patient advocate, your sister Jennifer is listed as the only individual, correct? Okay. And it sounds as though this credit union is the only place right now that you've had any problems exercising power of attorney, correct? And your sister's had no issues at all with the patient advocate form as of today's date, correct?
Yes, correct.
Okay. Nothing further. Oh, right. Yeah, let me just cover some background that you and I discussed. You have no criminal history, correct?
Correct.
You've not been investigated by Child Protective Services or Adult Protective Services, correct? You've not filed bankruptcy?
Correct.
There are no active collections against you, correct?
Correct.
And you have a sound credit history, correct?
Correct.
Nothing further.
Just briefly, thank you. We've covered how you alone were named as the financial POA and
Correct.
Jennifer alone was named as the healthcare POA.
Correct.
Did you ever receive any feedback that indicated that you were not supposed to serve in a healthcare role?
No.
Okay, and do you have any reason to believe that it would be a violation of the intention of the healthcare POA to have you serve in that role?
No.
That's all I have. Thank you.
Any recross?
No.
Thank you for your testimony. We return to your seat. Anyone else you'd like to hear from?
Yes, thank you. I'd like to call Jennifer McCormick.
Okay, Debbie Ames, Ms. McCormick is by Zoom.
Can you hear me okay?
Yes,
Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Good morning. Could you please say and spell your name for the record?
Jennifer Blair McCormick, JENNIFER BLAIR MCCORMICK.
Thank you. And what is your address?
2083 Gramercy Place, that's GRAMERCY, Hummelstown, Pennsylvania, 17036.
What is your occupation?
I am an associate professor at Penn State University in the College of Medicine. So I teach, do research, and serve on committees.
And how do you know Mr. Dickerson?
I've known Mr. Dickerson or Mel for 30 plus years. When I was getting my PhD, Mel was coming back to get his PhD, and we ended up in the same lab to do our PhD and became really, really good friends.
Thank you. Now, did you hear all of the questions to your brother Ned about the co-guardian petition?
Yes,
And would you answer those questions in the same way as he did?
yes.
Is there anything else you'd want to add that we didn't get to with him?
I don't think so at this time.
Very good. That's all I have right now. Thank you.
Any cross-examination?
Just a couple questions, Ms. Blair McCormick. What do you understand a co-guardianship to be?
I understand that my brother and I would be making decisions together about Mel's care, and that and that it's as my brother said, as Ned said, it's really intended to make sure that Mel has a happy and healthy life, is well fed, has a roof over his head, and is well taken care of.
So if you're jointly making decisions, let's say your brother gets in a car accident and he's in a coma. You couldn't make a decision because you wouldn't be able to have his input, correct?
That's correct.
So do you think it might be better to have one as a principal guardian and the other as a standby guardian in case something happened to one? There would be a decision maker available to make a decision for Mel.
That's an option, yes.
Okay. Is it true that you've not had any difficulties whatsoever with the patient advocate in helping Mel make with Mel's medical care? Is that correct?
It's pretty much correct. With his former primary care doctor, there was a little pushback, but he did end up honoring the medical POA.
You heard the questions I asked your brother about his finances and his character as far as arrest and involvement with CPS or Adult Protective Services. Would your answers be the same?
Yes.
Thank you. Nothing further.
Any redirect?
Just briefly, thank you. You described a little bit of pushback you got when working with a healthcare provider. Do you anticipate that Mel will ever need any healthcare providers in the future that he hasn't already worked with?
Yes, I do. I can't name those specifically, but I think as we age, we all require different specialists, and I can anticipate that, especially if he were to be hospitalized, then you would be dealing with a whole new array of healthcare providers. And potentially, I mean, you would be in a different healthcare system. So I think that, yes, we can anticipate that there will be additional healthcare providers in Mel's future.
That's fine, thank you. And you're not a biological relative, right?
That's correct. I am not.
So you would not be recognized as next of kin in the absence of paperwork, right?
That's correct. I would not.
Okay. So what you're asking for is the court to sanction what Mel has already indicated is his wishes by giving you the strength of a court appointment versus the less reliable power of attorney. Is that right?
Yes, that's what I'm asking.
Okay, that's all I have today. Thank you.
Thank you.
Any reprongs?
No.
Ms. Kelly, anyone else you'd like us to hear from?
Not today, thank you.
Mr. McFarland?
Just closing remarks.
Ms. Kelly?
Mr. Dickerson is incapacitated because he is an individual who is impaired by reason of mental deficiency caused by Alzheimer's disease, to the extent that he currently lacks sufficient capacity to make informed decisions or care for himself, and he has property that will be wasted unless proper management is provided. The appointment of Mr. and Dr. McCormick as Mr. Dickerson's co-guardians would be a means of providing continuing care and supervision with very little wait time in an emergency. The appointment of Mr. McCormick as Mr. Dickerson's conservator would be a means of managing his property and affairs effectively so that his accounts, his housing, his personal property would not be wasted. Your Honor, we believe the elements have been met for the appointment of the co-guardians and the conservator. Interested parties have had notice. We believe they'll be given opportunity to be heard if they wish on this matter, but we have received no objections. Therefore, we ask that you grant both petitions. Thank you.
Your Honor, as the guardian ad litem, one of the forms I received from the state, I had to fill out, present to the court, as the court is aware, if there is a existing medical power of attorney, or if there is a durable power of attorney, you must give weight to that because that was the intention of Mel when he was making these decisions. We've heard no testimony that the medical power of attorney has not been honored, Your Honor. Some speculation, but at this point in time, I don't think that's right. I think we have a current existing medical power of attorney. We would be actually violating Mel's wishes to add another individual to make medical decisions, as that was not his decision, and the durable power of attorney. It was that Ned make decisions as far as housing and finances, and not medical. Medical was left to Jennifer. As far as reasonable steps to deal with the credit union, I believe Ned has made those steps, Your Honor, as doesn't seem like the attorney was able to give a certification or validation or verification as the credit union wants, but there are no other issues regarding him dealing with the finances, but speculation there might be issues. At this point, I would agree that there would be need for a conservator, and I think that should be Ned, and the reason is because in the durable power of attorney, there was only one individual who was delegated that authority to make financial decisions, and that was Ned. So that would be the decision of Mel. I think everybody's on the same page right now that Mel is not of the capacity to make his own decisions. And as noted in my report, I do agree that he does have difficulty with numbers and with decision-making. Co-guardianship, I see problems with that, and that it takes two individuals to make a joint decision. If something were to happen to one, you wouldn't have the other available to make a decision if an emergency arose for Mel. So if the court does grant a guardianship, I think there should be a primary with a secondary backup, Your Honor. But I don't see there is a need for a guardianship at this point in time, just a conservatorship. Thank you.
Thank you. The court does find that all interested parties were given notice for purposes of today's hearing. And I do think that there does appear to be legally sufficient grounds to issue the orders, with the exception that we don't need them at this juncture. What I would like to offer to you is the opportunity, Ms. Kelly, for you to draft an order that recognizes that both your power of attorney and your financial durable power of attorney have been recognized by this court as being executed in full compliance with the statutes, and offer you an opportunity to come back in about a month after you've had an opportunity to see if that will allow you to resolve the issue with the particular bank that's objecting to the power of attorney. But at this juncture, with a power of attorney in place for medical decisions, the court would not have the authority to issue a guardian, or if I did issue a guardian, it would only be for any bits and pieces that haven't been covered by the medical power of attorney. The court also has the authority under 700.5408 to offer protective options as an alternative to a conservator. So I'd like to see if you are having any additional issues, because at this juncture, all of the testimony supports the fact that the durable power of attorney for healthcare is being honored, as well as the durable financial power of attorney, with the exception of the singular account. And if you'd like to list his specific accounts in the order that the court recognizes that financial power is valid as far as specifics go, if you think that would be useful to you, I'd be happy to sign that as well. And if, of course, they throw it out the window and refuse to recognize it, which is not always a situation that the statutes contemplate, because even a validly recognized power of attorney, as you can see, can be rejected by humans because of that factor, which is not necessarily contemplated in the code, but I do recognize occasionally as a reason to authorize a conservatorship. But rather than requiring you to file an inventory, annual accountings, reporting to the court, it's a rather invasive method of moving forward, which I don't think your family necessarily needs at this point to help take care of Mel. So I'd like to offer that opportunity to you, as well as adjournment, to see if that will work effectively. I have some time available on Tuesday, September 12th at 3 o'clock, which I'm happy to offer to you to come back together to see if that's been a working or effective solution.
I'm sorry, Your Honor. On the 12th of September, I'm engaged all day with one of the Bar Association probate trainings, actually. Is there another date that we could hold?
Yes. So we have some time, the afternoon of the 20th or on the 21st. Do one of those days work better?
Those are both open for me.
Yeah, I can make it open.
So how about 2 o'clock on Wednesday, the 20th? That work? You're welcome to join us by Zoom if you need to.
20th at what time, Your Honor?
2 o'clock.
I'm available.
All right, Ms. Kelly, I look forward to your order. We can cut the order to adjourn, but I'd like you to have a separate order prepared under that authority that I cited today to see if that will be a good working solution for your client.
Thank you. And then the understanding is that if it does work, we will have no need for the 20th.
Great. I'm sure you can deal directly with the clerk's office on that. So in the event I don't see you all again, it was nice meeting you. Thank you for sharing with me about your family, and good luck.
Thank you.
Thank you.
That's all for today.